to all the legal professionals joining us today. We're very happy to have you. This webinar is free, but we are inviting donations to the National Emergencies Trust, and we are extremely proud to be fundraising for this scheme and for the fantastic work that they do. We would ask you to please tweet about any of the Coram talks you've attended, and do check out Coram's YouTube videos. Before we begin, a few reminders as this talk is being recorded. Please can we ask you to mute your computers and turn off your screens to help with bandwidth. Please do feel free to ask questions using the chat function. We will try to incorporate those into the talk. If it makes sense for us to do so at the time, we will, or we'll deal with them at the end. You will have had an outline from Rakaya about the topics our discussion is going to cover today, and Anarkali is going to begin by discussing RES.
So good morning, everybody, and it's really nice to have such a good group of you this morning. What we thought we'd do is talk about this new case of RES, which is a really fascinating case about parental alienation. And because it's such a helpful case, what I think Sophie and I are planning to do is kind of weave it through the rest of our talk as we go along. So there are several points actually that we learn from RES, which is about the nub of this case is it's about a mother who has joined a cult some time ago, and as a result of being a member of that cult, increasingly began to alienate the father from the child's life, because not because the father was necessarily a bad father, although that seems to be what she feels about him, but also mainly to do with the fact that he was bad because essentially he wasn't doing the things that the cult required members of that cult to do to, for example, achieve reincarnation. So it's a cracking read, factually, and I would actually invite you to read it for your own sake, because the facts are completely off the scale. But actually, in terms of how we deal with parental alienation and how it helps our understanding about alienation, I think really that's where the utility of RES comes in. So there are three main points I take from this case. The first is that RES very helpfully identifies what alienation is. So it gives us a working definition, which I think up until this point we've lacked as practitioners. Secondly, it analyses the impact of delay on proceedings and issues a very strong warning, in my view, to other judges. And thirdly, it discusses how the disposal of a case where parental alienation is at the core of the issues, that disposal really needs to reflect very carefully what those issues are, and it can't kind of fudge it. So the first thing it deals with, as I've said, is what alienation is. And I just want to read a little bit of this case out to you. So paragraph 8, this is the Court of Appeal. They say, it's necessary, nevertheless, to identify in broad terms what we are speaking about. For working purposes, the Kafka's definition of alienation is sufficient. Quote, when a child's resistance / hostility towards one parent is not justified and is the result of psychological manipulation by the other parent. That's the end of the quote, but the judge goes on to say, to that may be added the manipulation of the child by the other parent need not be malicious or even deliberate. It's the process that matters, not the motive. And then they go on to describe all the sorts of different features. This is not an exhaustive list, by the way, that alienation can take place through. So they say, this may include portraying the other parent in an unduly negative light to the child, suggesting that the other parent does not love the child, providing unnecessary reassurance to the child about time with the other parent, which is a really interesting point, contacting the child excessively when with the other parent, and making unfounded allegations or insinuations, particularly of sexual abuse. They then talk about how there's obviously a spectrum of severity, and the remedy is going to depend on an assessment of all aspects of the child welfare. So what we know as practitioners is, it's true, isn't it, that not every case runs in the same way. Not every case is going to be as severe as the worst cases that we read case law about. But actually what the court is keen to do is make sure that there's a proportionality between the way in which these cases are disposed and the severity of the mischief that the case is trying to manage. That this point about delay, I think, is perhaps one of the most helpful points that we are going to find in this case, because as all practitioners will know, we have a court system that is utterly beset and extremely vulnerable to delay. And when you've got parental alienation, that's exactly the sort of problem that is going to grow unfettered in an environment of unchecked delay, which is actually the sort of environment that we typically litigate in. And so what's fascinating about RES is that it refers to this case, a case from last year called, I think I'm pronouncing this right, Pisica and Moldova. And really that was a case where the alienated parent, by the time it came to court and had facts found, it was too late essentially to do anything with the children. And you'll know that. I mean, there are parallels all over the sort of litigation that you no doubt as practitioners will have dealt with, but also all to do with, you know, for example, in the case of Re J, which Sophie and I will come to, that's a really good case actually that runs along parallel facts, where by the time it was litigated properly, it was too late to do anything with the children. And in the case of Pisica and Moldova, what the court found was that actually the alienated parents' human rights, Article 8, was interfered with because of the quality of delay inherent in the court system, which meant that by the time that the case was resolved, it was really too late to do anything. So what these judges say very interestingly about that point is, and I'm going to quote again, in summary, in a situation of parental alienation, the obligation on the court is to respond with exceptional diligence and take whatever effective measures are available. The situation calls for judicial resolve because the line of least resistance is likely to be less stressful for the child and for the court in the short term, but it does not represent a solution to the problem. Inaction will probably reinforce the position of the stronger party at the expense of the weaker party, and the bar will be raised for the next attempt at intervention. Then they go on talking about the welfare of the child, but they finish off that paragraph by saying this: what will amount to effective action will be a matter of judgment, but it's emphatically not necessary to wait for serious, worse still irreparable harm to be done before appropriate action is taken. It's easier to conclude that decisive action was needed after it's become too late to take it. So it seems to me that RES in many ways is a call to arms for judges and the courts generally to be less delaying and much more decisive and actually somewhat aggressive about the way that they deal with these cases. So that's my take on this case, and I think for all the reasons I've outlined, it's a really helpful case for practitioners. Sophie, I mean, what did you make of RES?
I agree with you about the helpful shift of emphasis in terms of the priority now really lying with the child's wishes and feelings. But what I'm concerned about is that might lead to more of a invasive approach for the children at the heart of the case. And I am aware, of course, that there is a tension between RES and REL, which was only heard last year. It was a 2019 case in the High Court and provided reassurance that it was accepted that an experienced social worker could ascertain the children's views in a way that doesn't place the children under further emotional and psychological pressure, and that even if direct questions are not asked of the children, this does not mean that the child's voice has not been heard. So whilst it's clearly material and highly relevant and important to us understand the effect of parental behaviour on the subject children, we also have to take into account the children's personalities, their characteristics, their age, their understanding, which all have a bearing on how they may or may not manifest their reaction, perhaps depending on their resilience. So the risk is there could be increased scrutiny of the children's wishes and feelings in circumstances where we've had a shift in Section 7 to welfare reports rather than wishes and feelings. We know about the detrimental effects of litigation on children, and a common problem is the exposure to talking to professionals about their lives. What's your view?
I mean, I entirely agree. And I think the concern about this focus on the children, which is really at the heart of RES, so that you look at the child for the evidence of you look at the child for evidence of parental alienation rather than the behaviours, and then you work from there to work out how it's come about. So you look at the parent's behaviour almost as a secondary. I think the difficulty is that actually it does mean that you've got an extremely invasive environment for these children to be litigated within. But then realistically, parental alienation cases are some of the most invasive litigation that you can possibly have in private law proceedings anyway. And I don't really know how that's going to be avoided. I mean, I can't personally fault the sense of what the court, of the way in which the court is approaching this, but I do agree with you that there is a tension between this and some of the things that seem to have been endorsed in Riel. I mean, it's interesting because I had a case very recently where which struck me as a classic kind of pseudo parental alienation case, insofar as in many ways it carried many features of parental alienation, but actually it wasn't one. So I'll just outline it to you. A little girl had actually voluntarily left her mother's house to go to her father's house, and she then didn't want to see her mother and has not seen her mother now for 2 years. She is very clear about a quality of rejection of her mother. Now, when the guardian went to see the child, what she also found undoubtedly was evidence of the father speaking of the mother in an extraordinarily negative way, and to the point where when the guardian said, maybe you shouldn't do this in front of your child, Dad said, well, she's heard it all before. There's no point in me keeping it a secret. It's not like it's anything new. And so actually there seemed to be and he came across as quite a controlling man, if I'm frank. But so there seemed to be an enormous amount of evidence actually that this child was being directly affected by the father's negativity. But when the guardian did some proper investigation, what she concluded, and I've got to say, I think she was absolutely bang on the money with this, is that this was not a parental alienation case. And the reason for this is because when the child started speaking, she didn't convey in any way classic alienation tropes. So when she spoke about her mother, it wasn't to reject her mother. It was to say, I really love Mum, but I just wish that she could understand where I'm coming from. And because she can't, I find it so upsetting to be around her, and it upsets me, and that's why I don't want to see her. And meanwhile, she was in touch with all her younger maternal siblings. She was in touch with maternal family. They were an incredibly important part of her life. She actively wanted a relationship with her mother. Although she'd heard her father's criticisms, they didn't seem to reflect her own views about her mother. And so what seemed to have so many features of an alienation case, actually when you look at the heart of this, which is the child's behaviour, those concerns actually evaporated, because this isn't really an alienation case. It's really one where the mother just wasn't able to parent this child in the way that she needed to. And the father's own views, despite being pretty vociferous and undoubtedly extremely negative, don't seem to have got to the heart of this child. And I think what I find interesting about parental alienation, and the reason I really think that RES is helpful, is because actually what you're looking at time and time again is the behaviour of the child and the extent to which they're taking on board the negativity of those parents. And as you pointed out, Sophie, they don't always do that. It depends on the child and those child's characteristics. So, you know, how do we separate cases with features of negative behaviour from parents from, you know, how do practitioners like us sort of separate those cases from cases where parental alienation really lies at the heart of the dispute? I think that's one of the most difficult things that litigators struggle with in this case. And I suppose what I'm trying to say is that RES gives us a steer of doing that. I mean, what do you find in practice? I know you do a lot of these sorts of cases, Sophie. What do you find helpful?
Thank you. I find that it's still a developing area. And so we're still experiencing on the coalface a smorgasbord of different judicial approaches. I don't know if that's what you've experienced.
Very much.
So even as recently as October, when we conducted the Coram conference, I was expressing that identifying parental alienation is akin to addressing the elephant in the room. And sometimes the court can be quick to say, when faced with these allegations, that it just wants to get contact up and running. Mm-hmm. It may say it's not the past, but the future that concerns it, that it's of concern that the fact is the child is saying these things, but that the reason isn't actually very relevant and doesn't concern the court. So despite the apparent shift in emphasis to the effect on the child, I think we both agree that it's going to be helpful still to analyse the alienating behaviour of a parent, running alongside a dynamic of probable court non-compliance to give the context for the child's reaction. What do you think of the suspended residence order method in light of Riel, in a bid to avoid the perhaps last chance saloon pattern, which we're seeing again, I think, even as recently as in Ries?
Yeah, so that was quite an interesting feature of Ries, I thought, because Riel makes it clear that you just don't need to be giving chance after chance after chance to parents before you transfer residence. And, you know, this idea that a transfer of residence is a weapon of last resort is now completely obsolete, thanks to Riel. I don't think it was resurrected in Ries, actually. When I looked at, I was rereading Ries in readiness for today's talk, and I did notice there wasn't formally a suspended residence order there. But I mean, there were so many warning shots across the bow that this mother would have to be completely deaf not to recognise that that's what the Court of Appeal had in mind. I mean, I thought it was, they described it as being quite delicately balanced, but I thought it was a really interesting interim solution, because I guess what it does is it really helps test the alienating parent's commitment to being able to provide an environment which is actually genuinely changed for that child. I think suspended residence orders are one of the few environments in which, for example, therapy, which I'm generally quite negative about, can really work and can really flourish. And I guess I felt that when I read Ries, what that suspended residence order, although it wasn't officially made, I know, but what that kind of status of that state of affairs did was it kind of took into account this sense of desperation that you really got from this child at being in the middle of this horrible dispute between her parents. And I think in some ways it was an acknowledgement of how difficult it is to manage these children's feelings within this sort of litigation. I mean, I think it will be very interesting to see what the President does with this case in July. But at least, I mean, ideally, although it may be totally unrealistic, that child would remain with her mother and her mother would change. And I guess what this status quo means this interim status quo means is that if the mother can change, this would be the time that she does it.
I agree. And I also think it reflects, obviously, the fact we are in a remote hearing arena at the moment, but also that she has such a high degree of vulnerability, perhaps arising from her affiliation with the cult. But it is a very measured approach from the Court of Appeal, despite the strong sense of the direction of travel for this case. And ultimately, I think it's giving the president the last word on how to deal with it, which is always helpful with the consistency of approach, given that the other cases are his decisions. So looking then, taking a step back at our role as lawyers to assess the case, to consider the trajectory of litigation as if mapping out a flowchart of steps to be taken, ensuring that nothing is missed, that you can track your strategy, and that you are giving the very best advice. How would you pinpoint the steps in how we litigate these cases, Anarkali?
I mean, I think there are so many different factors to consider, and hopefully by the end of this talk, practitioners will have a clear idea of what things to focus on. But for me, the mistakes that most people make, or people that I'm up against make, are, I think they're too complacent. I think they're not litigating aggressively enough or carefully enough. And I think if you're going to win these cases, you need to be litigating them very carefully, but very aggressively. And when I say that, what I mean is extremely tactically and with a very clear strategy. I think we now have more options at our disposal to deal with alienation cases than we ever did before. So, you've got the transfer of residence, you've got suspended transfer of residences in a way that actually I think the courts are beginning to mean more than they ever did. And also you've got much better judicial recognition, despite what you'd say, I agree with, about there being a smorgasbord of judicial approaches. But for me, I think most advocates that I litigate against just don't run their cases tactically or strategically enough. And I think that there is this sense that if there's an 11-year-old who doesn't want to see her mummy or daddy, then there's nothing that the court can do about that. And I think that is so commonly a fatal mistake in people who seek to defend or even make these applications. They just give up with that, and you just can't do that, really. That's I think for me the first thing I would say. But I mean, practically speaking, I guess that's what this talk is about, is trying to get together some practical advice for everybody to follow. I mean, what would you start with, Sophie?
My approach would always be front-loaded in its preparation, not reactive. So setting out the case in the C1A, not overlooking that document and its importance, but also thinking ahead to perhaps a future Scotch schedule that you will want consistency as between those two documents. Of course, there may be further instances that you will need to draw on. But if there is clear alienating behaviour, then we are exhorted to use the structure of Practice Direction 12J to bring this case to an early fact find. And the case of Reed J, which is the contact orders procedure case from 2018, which you alluded to earlier, in the Court of Appeal, makes the presidential position very clear if we hadn't already picked up the heavy hints from his two speeches the previous year, which were to Nagal Row and Families Need Fathers. The court may suggest that the issue of fact find is to be listed as an issue to be considered at a future hearing, but I'm concerned about that approach and have long advised and lectured that early fact findings are key, and RES, fortunately, endorses that view.
I completely agree. I think a really common mistake is actually not to force it through to a fact find at an early stage. And I get instructed on a lot of 16.4 cases because obviously this is my area of expertise. And really what happens is that you get a guardian after there's been about a year and a half of litigation that's got absolutely nowhere. You don't have any facts that have been found, positions have been entrenched, and the whole case is completely snarled up. You kind of have to start from the beginning. It's very difficult to do that cleanly. So I suppose what I'd really make clear to practitioners is that what you need to be doing is treating these allegations in the way that you would be treating domestic violence allegations. And you've pinpointed them to 12J, which is what the President himself has done in the case of Re-J. And what you need to be doing is thinking of these cases not using the typical tripartite structure that we have of, for HEDRA, DRAs, final hearings. These cases fall off that structure in the way that domestic violence cases fall off that structure. So, but I think the most helpful structure for you to be thinking about is the 12J structure, organising your case or strategizing it around that particular structure rather than the usual tripartite one.
So not engaging the court's attention towards the fact find at an early stage causes delay. But the other delay that I've seen in practice is the introduction of therapy, perhaps before facts have been found. What are the parties going to be dealing with in therapy? And so my view is that if we are going to look at therapy at all, and I know your views about that, we need to treat any expert report with caution, unless they have reviewed the alienating parent's ability and commitment to change. It's not just about the child. The environment has to be improving, in my view. There's also an issue, of course, about therapy inherently, about consent. And I have seen cases where there's been consent in the face of the court, but then equivocal behaviour over instruction of a therapist or an expert, which rings alarm bells in my view. And it's not just non-compliance, but it can be a symptom of a bigger problem. So therapy, I know that's a flashpoint for you.
Yeah, I mean, I just think it's so often an absolute waste of time, and all it does is just delay proceedings. I think it's a common mistake, unless there is a clear judicial stick, such as a suspended residence order or facts that have been found which lead towards a transfer of residence. I have never known therapy to be effective. It's just a really expensive, delaying tactic. And I think you really need to be very wary of this. And courts kind of do quite like the idea of therapy because it kind of gets the case away from their list for a really significant period of time. So there is that, there is, from their point of view, an attraction to it. And I think really you've got to resist that. But also I think, picking up from what you were saying, Sophie, about whether or not it works on the child will change if the parent changes. The parent is, the alienating parent is the key to this. And if that parent changes, then 9 times out of 10, the child will follow suit. So really what you get a lot is alienating parents who say things like, yeah, I do agree that, Poppy needs therapy because she's ever so upset about seeing her dad. That is not going to work. That is a mother or a father who needs to have therapy themselves, because if they change, then Poppy will change. And that's exactly why therapy should not be agreed to. So, yeah, I mean, that's my view.
Looking at this,
I was going to say, what do you think about, because I mentioned transfer of residence applications and, with fact finds. I mean, what do you think about making those applications?
I think they're essential, but I do think that timing is really important, because you don't necessarily want a full transfer of residence application in with your initial C100. And the reason I say that is it's often seen as premature to the court. It's often seen as a tit for tat exercise, raising the temperature. And so tactically, I often find it's better and more palatable to bridge the potential for a transfer by applying for a shared lives with order from the outset. And it gives that sense that this can be an interim measure, that it's not improbable or unlikely or in any way against the child's interests. But we can also flag, can't we, that the current non-resident parent is reserving their position on a transfer at the earlier stages of litigation. And then I think you need to consider a move of position to a sole transfer of residence application, upping the ante perhaps, after a fact find, if you've succeeded on some of your facts or all of them, in order to inform the resulting Section 7 report, so that that focus can be zoned in on that issue. What do you think?
Yeah, totally agree. I think you really need to, you know, when I talked at the beginning of this kind of section about litigating aggressively and tactically, I think you need to be setting the agenda right at the beginning, in such a way that you are realising the case. So you need to be very you need to be lining up exactly what you want from every single hearing and how that's going to help you in the next hearing. And I think what you want to be doing is also opening and closing doors in recitals, and actually in the sort of letters between solicitors before and during the time in court. So for example, if you're for a parent who's trying to change the residence of a child, and you know, one of the things I advise very early on, and you know my views about therapy because I made them more than clear about 2 seconds ago, is that you send a letter inviting the resident parent to engage in therapy and see what their response is. Because actually I think it's really helpful if you can say at the end, for example, towards a fact find or after a fact find or after a final hearing, and say, look, we explored this idea with them X number of months ago, and all they said was that Poppy needs to have therapy. This shows a real lack of insight in how the reason why we don't think that this mother or this father has got the capacity to safeguard and protect their child effectively, and why we need to be the ones that are looking after this child. So you also need to be, in my view, suggesting really creative contact and indirect contact. So during COVID, you know, why is it that you can't play some sort of one of these, like, you know, Fortnite or one of these games that the youth, you know, like playing? Like, why can't you be doing that with your child if you're not in the same house with them? Why can't you be reading books to a younger child over Skype? Why can't you be playing games with them? So, you know, you need to be always suggesting really creative ways to resolve the issue, and the response to those creative problems being solved is actually part of your case. So before the final hearing, you want a witness statement saying, you know, over the course of litigation, in the nose of the court, you know, I offered this, and this, and even when the court was watching this case, she refused or he refused because they said this, and this, and it's not. This shows actually it's not about the child. It's about the parents and the quality of their intransigence.
I agree. The references there are for orders, recitals, for letters in correspondence, and also I would say that a very important document setting the tone of the proceedings is the Schedule 2 letter. So looking as early as we can at the CAFCAS interview procedure, we need to be giving advice about which points our clients need to make and how. There's a useful resource that we as practitioners will know about, which is the CAFCAS Child Impact Assessment Framework, which is online. But the headings, the tools that they use, are actually contained within the resources for professionals. And I would be directing my clients to look at those before they speak to CAFCAS in that 5-minute meeting that they'll have by telephone the day before court potentially. Very few parents in these sorts of cases will have attended a MIAMS, and the temperature therefore can remain high at the stage of the safeguarding interview for the Schedule 2 letter. Your client needs to be coming across as reasonable and reasonably concerned. Because of course, if we are on the receiving end or having to represent people who have raised and then dropped allegations, they need to know that these can be interpreted as malicious. The concerns therefore have to be well-founded, and we cannot proceed on an assumption of parental alienation in the way that you've outlined. Some cases look like they might be later on, but we don't know necessarily at the very early stages. These are the first stages of our pleadings. And how have you gone about this in practice?
Well, I have actually advised on what to say to CAFCAS officers, not in the sense that you know, you say this or that, but actually I've been instructed to advise about you know, a resident parent with a plethora of concerns about the non-resident parent, and actually how she communicates those to the CAFCAS officer in the most effective way. And I think what's really interesting, so RES, going back to that case, they actually do talk about the Schedule 2 letter that the father in that case wrote, not wrote, but that was written on his behalf through his conversation with the CAFCAS officer. And they go back to it as to show the consistency of his concerns over a period of time. And I think also tactically, those Schedule 2 letters can be really important, because if you raise some concerns with the CAFCAS officer and they're not really investigated in any meaningful way at the Section 7 report, then when it comes to challenging that evidence, you have a really clear evidential trail to refer the Section 7 reporter back to. I mean, I think when I say advise about the Schedule 2 letter, I don't tell people what to say. Obviously, that would be completely wrong, but I think people get flustered at that stage, or clients can get flustered. And it's really about helping them to work through what their case is about at that early stage, so that it's always clear the whole way through, and that they don't miss things. Because quite commonly what they do is they say, oh, I didn't raise it with the CAFCAS officer then because I just forgot, or I didn't think it was going to be such a big deal. So I do think it's actually possibly worth speaking to them about that to begin with.
Yes. And ultimately, aren't we building towards needing witness statements in these cases? Because position statements with proposals aren't going to be enough. So thinking about how our clients set the right tone, they're going to need to be referring back to any schedule of allegations that they raised either in the C1A or in the Scott schedule that they're no doubt going to be directed to file. Thinking about the flowchart that I talked about at the outset of this section, considering the witness statement, setting out the allegations in C1A, there needs to be consistency throughout those documents. And I really recommend drilling down into instructions at the early stages to establish whether a fact-finding is in fact necessary, using headings from the CAFCAS tools as a checklist, because that's what CAFCAS should be looking at.
See, last time I did a webinar for Coram, I got a question from a solicitor, and it was essentially, how do you write a witness statement in cases of parental alienation without it being a mudslinging exercise? And I thought that was such a good question, actually, because really, when you're dealing when you're representing a parent, their case is essentially one of complaint. And how do you kind of make that case more interesting for any tribunal that it appears in front of? It's a really difficult conundrum, I think, and not one that is often done excellently in my experience either. So I suppose the tip I would really give to people drafting witness statements in this situation is try to look at it from the judicial point of view, because actually judges, I know clients want judges to know about how annoying their ex-partner is, but judges don't really care about that. What they care about is how the child is being harmed by this litigation. So I think more effective, so, you know, for example, if you have you know, sometimes you get these cases where there's this absolutely horrific undercurrent of emotional, like emails between the parents. You know, on the surface, they kind of pretend like they're getting on, but, you know, the minute they get home on their own, there's just some absolute, they start writing these horror show emails to each other. If you were a parent who was just receiving them, which does happen, and not really kind of engaging in them, what you would say is, I really do very much try to protect Poppy from the aggression and the dynamic between me and Mr. So-and-so or Miss So-and-so. But the problem is, every time I receive one of these emails, it's so upsetting. And she is now really geared up to noticing that. I do my very best, but when you get emails that are telling me to go and die or be raped, it's very hard to parent her in the way that I want to be able to. That is a more interesting thing than saying, I find it really difficult to get on with them when they tell me I should be raped. How am I supposed to work with someone like that? No, that's the shift. So I would really encourage anyone who's drafting statements to kind of always start with the child. So you start with the child, and then you work back and say, this is the state of my child now because of this dispute. They're not, they can't, they're very anxious, and I do my best to protect them by doing this, this and this, but I can't do everything. And it doesn't help when we get to handovers and he calls me a bitch to my face in front of her. That's the way you should be dealing with it. Start with the child.
Completely. Well, it sounds like it's a continuation of any domestic situation between them, or contact being used as a tool of coercive control. And that's actually falling square within PD 12J, in my view, in any event. And so my concern, just thinking about statements, is that if the child is the source of the evidence, if we are looking at our child, scrutinising the child, there is a risk that this will encourage greater focus on gathering evidence from the child. And I have been, and we all will have been, presented with videos and sound recordings. I had one in a very long running case of a crying child on the bus en route to contact with his nanny. And I have had to advise clients that the court won't approve of children being videoed rather than comforted. And the court cannot know the context or what has prompted the reaction, which calls the weight into question. So my advice, therefore, is that clients should be logging concerning behaviour, that they should be shutting down any negative discussions, not fanning the flames, not asking leading questions. Children are astute and they are sensitive, and they will be harmed by that process, but they can also learn that they get attention for negative discussions. Of course, in an ideal world, we would have CAFCAS or NIAS or an ISW commissioned to investigate the child's response and the effect on the child as a benchmark early in proceedings. And that is an investigation, effectively, that can't be confused with a welfare assessment necessarily. But we have got an issue with resources. We've got an issue with proportionate working. We can't deny also that the age of the child matters. So if we're talking about very young children, it may be more difficult to make out from them the evidence that the court might need. We all have to tailor our advice accordingly. Of course, at the top end of the spectrum with the teenagers, you're going to be in a situation where they may paint themselves into a corner. They may choose that line of least resistance. They may want a quiet life and some peace. So what should we be doing in those circumstances? I think you're absolutely right. We need to be focusing on the evidence in relation to the effect on the parent as a parent of a child who's being affected, but also look at the positive aspects of your client's behaviour. So whichever side you're on, if you have a potential transfer of residence case, your client needs to promote contact. The flip side of that is you need to show what the other parent has not done in order to promote contact, and see what that has done to the child and your relationship with the child. So indirect contact is very important.
Yeah, I agree. I mean, I think that indirect contact in so many ways is the real litmus test of a parent's commitment to fostering a relationship with the other parent. And time again, it's indirect contact that is the stumbling block in these cases. And I think when that happens, alarm bells should be ringing. because actually it's really not rocket science. It's not hard. It's a phone call. It couldn't be easier. Or it's a Skype call. It's certainly beyond, it's not beyond the ability of any child in the whole country to do. I think though that if you're angling for a transfer of residence, the one thing before we move on from witness statements that you really need to remember, if you are a parent who wants a transfer of residence, you need to be able to show that you can really promote contact with the other parent. Because, and obviously, it goes the other way. So if you're trying to resist a transfer of residence, what you'll be saying is the other parent can't really promote a relationship with me, and this is why. And I mean, the transfer of residence cases I've done in Re-H and Re-L, those quite important cases about transfer of residence, the single biggest issue is actually about that alienated parent's ability to promote the alienator to that child in a healthy way once the child transferred. That has been the issue on which this case turns. And it's quite often overlooked. So if you think you've got the wind behind your sails, that is the one thing you absolutely need to get into a statement. This sense that they only have one parent as things stand. If they come to me, they can have both. So, yeah, why don't we go? So I think talking about documents again, do you have any further kind of tips that we can give?
I do, because I like to think about my cross-examination from an early stage. And so looking at the chronology of events very early on is important. To give you a specific example, you may have an agreement, even a consent order on contact at court, but what's happening outside of court? A specific example I had recently was a resident parent in a case I inherited had historically agreed to the resumption of contact, but only he knew that he had made a report to the police the day before, and therefore the mother was arrested when she had the child in her care. The idea of a parent being called into interview, the idea of a parent having bail conditions that will impact on their contact that's been ordered even by agreement. These are all factors that you might want to look for. More generically, is the parent offering FaceTime or Zoom calls actually following through? So comparing the emails, the texts with what's going on the ground, and a diary of actual calls, I think always helps. Are they in fact blocking the non-resident parent's number? It's very easy to say, yes, you can have FaceTime, but then it's not actually possible in practice. My common advice is that parents need reminding that they can't just express their child's negative opinion and then hide behind it. They need to show proactivity and positive reinforcement, not just a vacuum. The days of saying, we just don't talk about the other parent, have to be over, because that is not giving the child emotional permission when they are in the, say, resident parent's care. What do you think about that?
Yeah, I mean, I agree. I just think it's so often an excuse. You say, what conversations do you have about so and so? And they say, well, we just don't talk about them. That actually is a way of saying to the child, this is somebody I don't want to talk to you about. And this is exactly the sort of advice that parents who are on the verge or who are actually alienating their children really don't want to hear. But actually, I think it's really important that they are advised, because if things blow up in their face, which they might do, they need to know that this is what you told them to do, or they at least need to be aware of how the case is going to run. They need to be paying some sort of lip service, at least to that, I'd have thought. I think the other issue, sorry?
What happens if we don't get the fact finding that we want?
Yeah, so this goes back to our earlier discussion, I think, about trying to follow the outline provided by 12J, and also the point that you made about how there's this, I really liked your use of the word smorgasbord, because I never really used
I
it.
stole it from McDonald in relation to remote procedures and videos.
Yeah, it's really good. So anyway, so it's a combination of both of those things, a smorgasbord of judicial approaches, and the point that you and I have been talking about trying to get 12J, you know, following that practice direction and listing it for a fact find as soon as you can. I think that, so sometimes, yeah, basically you will get a judge who just says something along the lines of, well, this strikes me as an issue for final hearing, and if the parent is, you know, I suppose if the resident parent really is alienating, then we'll just deal with it then. You know, that will come out in the evidence at final hearing, and the court will deal with it then. I mean, look, sometimes you just can't avoid judges saying that. I personally think that's pretty a rubbishy approach, but you know, this is what litigation risk is about. What I think you need to do is you need to be, as an advocate, just really, you just need to be pushing that letter all the time, don't you? Because I suppose I had this quite recently where the judge was like, well, all of this stuff can be dealt with by way of a rolled up hearing at the end. It'll be a fact find and a welfare hearing. And in fairness to him, kind of one day in, he did make it clear that he thought that maybe we couldn't deal with all of it. It couldn't be finally disposed of at the fact find or that final hearing. And really by the end of the evidence and the end of submissions, he seemed to be very, he totally agreed that was just an interim position. And he, I think, was extremely alarmed by the quality of the resident parents' intransigence, her lack of curiosity as to why the child had taken that particular deep stance against the alienated parent. And that just became a stepping stone. But I think what's helpful is that Ries, it's very clear when you read Ries that the disposal of this case needs to be proportionate to the issues of concern in the case. So where the judge at first instance had been really happy to take undertakings from the mother that she was going to change and engage in therapy, what the Court of Appeal said was I mean, I'm using my word, not theirs, was quite a naive approach, because it just didn't deal with the mischief that this mother presented. And I think when you're dealing with a hearing that is called a final hearing, and you want it to be turned into a hearing that is not a final hearing, Ries will help you to reiterate to the court that actually a really swift resolution to this case is not going to be in these children's interests, typically. And sometimes it will be. Sometimes your client just won't want to fight or won't want to keep litigating, which is perfectly legitimate. But, I think you need to know how to turn a hearing that's a final hearing into a hearing which isn't a final hearing, if that makes sense.
Yes. It's happened in my cases where there's been a problem with the expert's plan. For example, a very good and well-respected expert, but recommending a Rolls-Royce package that was really never going to be commissioned given our Robin Reliant budget. And so we had to adjourn the final hearing so that we could ask for the local authority to consider what services they could offer. And they did actually engage and become involved. But then there was, of course, a period of review, and that does, of course, increase delay. It is, however, ultimately sometimes the only way that things will finally resolve. What else would you do in relation to experts?
Yeah, I was going to say another thing you can do, actually, if you want to turn a final hearing into a hearing which isn't final, is to make Part 25 applications, depending on how you think the evidence is going to go. So if you feel like there's a chance that the resident parent is going to start saying quite negative things or things that suggest very strongly that they're alienating the child, make a Part 25 application for an expert and say that it needs to be determined once the court's heard the evidence. So it's a tactical application, and obviously if the court decides there's nothing in it, then that application gets kicked out. But I do think it's worth doing, because at the very least it puts on notice to everybody that you don't think this is going to be the end of the case. You just think this is going to be a step, an important step in the case. So I mean, that might be helpful actually. It might be helpful now if we just turn to kind of experts and guardians generally, because I think there's a lot of uncertainty about when to make Part 25s, when to bring guardians on board. Do you have any particular advice that kind of extends beyond the particular facts of any fact-specific case you've been doing?
Yes, in that if you think you're going to be needing experts at some point down the line, and if you are going to make your guardian application at some point, make it early so that the guardian has input into the selection and instruction of an expert. Otherwise, you may find you need a guardian later on, and they have to put a hold on what's going on because they haven't had input. So working out your sequence of applications is important in my view. And I don't think you lose by asking for a guardian, because if anything, you're highlighting the fact that you're taking this case very seriously, that there is a concern about the voice of the child. And in circumstances where we have these limited resources in terms of a family court advisor and what they might be able to do under a Section 7, a guardian has more scope. So I would also say, however, if you are going down the road of picking experts, you need to do so very carefully, and you need to consider your questions to them very carefully, because there is, unfortunately, I think, a tendency at the moment for people to hold themselves out as parental alienation experts, which immediately makes it difficult to agree on instruction of them, because of course the other parent who's denying parental alienation doesn't want to touch them with a barge pole. In terms of questions, what ultimately do you need the experts to be reporting upon? What do you need them to say? And how will your questions help them to say it?
Yeah, I mean, I totally agree. In terms of asking the court to consider consider appointing a guardian, I think if you're dealing with a second litigation between parents who don't get on, that should be something you're thinking about right at the very beginning. So at the FHEDRA, you should be making that application. If there are allegations of sex abuse against your client or being made against the non-resident parent, again, you want to consider appointing a guardian. Or if the child has completely refused to see the non-resident parent, again, I think there's a good argument for asking for a court to appoint a guardian. Or, for example, if there's some compelling reason as to why the resident parent's account cannot be taken at face value, again, that seems to me to be guardian territory. But I think you do need to be proactive about thinking what you can get a guardian on board with. And they can help with any, certainly financially they can help with the appointment of any expert. So that, like, practically speaking, they're actually a really good tactical thing. But like I say, you do need to get them on board quite early. And one of the reasons is because it takes quite a long time to get one appointed to your case in practical terms. So you want that work to be done sooner rather than later, I would say. So yeah, I mean, I think that's kind of that's brought our topics, the list of topics that we had thought to discuss, to an end. Should we go and have a look at the what's on the chat?
I've just been looking.
Yeah.
And yes, there will be notes, and also the recording will be available after this. But Denise has asked an interesting question about types of therapy. And Anna has suggested systemic family therapy. I'm also finding that guardians in particular have preferred experts who can inform the therapeutic process, even if they can't, of course, conduct it themselves later on. So the type of expert who knows about therapy. I'm thinking of specific names. You can email me if you want them, but that's this sort of thing that we need to be targeting.
Yeah, Adam, you asked if there are any precedents letters, such as Schedule 2. Now, the Schedule 2 letter comes from Kafkas, I think. Do you mean a different type of letter, or is there? I think I was talking about letters between solicitors, like correspondence is really what I meant. When you're kind of trying to shut down doors and do it tactically. So perhaps I was a bit confusing when I was talking about that, but I think that's what I meant. I'm glad that you like smorgasbord as well. Oh, right, okay. Hang on a sec. So Anna had something about mother. Let me just get these comments up a bit more. Yeah, so a case in which mother is causing mischief early on in the separation, how quickly would you issue? I don't know about you, Sophie, but I would be inclined to issue quite quickly before it gets out of hand and gets too intransigent.
Yes, do not have a status quo evolve. Just to
exactly. Yeah, and I think you will find a lot of the issues resolve if they get a clear steer judicially, which obviously you can't guarantee, but you can hope for, and or they get legal advice themselves. So I would be inclined to be quite proactive about that. Leona, yeah, you don't have those letters in Northern Ireland. That's annoying, isn't it? Okay.
At what point in the proceedings should you be raising issues such as the resident parent not allowing the non-parent to read bedtime stories to the child, especially when currently no direct contact? At every hearing and in litigation, I would be detailing the approaches in correspondence, because these things shouldn't be left for the court to decide. These are parental responsibility matters. What's the harm? This is really what we've been saying about indirect contact being the litmus test. It benchmarks the approach that the resident parent is taking.
But also, I mean, the resident parent needs to be showing, if you want to successfully defend transfer of residence case, and you're a resident parent, you need to be showing very clearly that you are promoting contact in a really strong way. What I mean by that is, I had a case recently where a mother was being accused of alienating children, and for what it's worth, there was quite a lot to that. But what she did was she started doing this really creative thing of, like, because the child was really little, she'd start reading a book that the father had on Skype. And so dad he would come in on Skype, she'd get to the end of page 1, then he'd start reading it to the child, and she'd just sit there with the child, and he'd be saying, can you see the bunny in this picture? You know, what's the bunny doing? And then actually, so you really need to be integrating the non-resident parent into that child's life, which is such a challenge for parents when they hate each other.
Mm.
It is such a challenge, and you know, we've all kind of been there with exes that we don't like, but it just has to be done if they want to keep those children with them. So Hattie Gibson has come through with an absolute corker of a question, which is, if there are older children who don't speak to the father, potentially because of parental alienation, they're influencing the younger child, how do you deal with this? I think these cases are so fascinating. I've had 2 of them at the moment, and they are absolute crackers to manage. So one, I think what you deal with there is a resident family dynamic. It goes beyond just dealing with that mother, or sorry, the alienator. I keep using these quite gendered pronouns, but in the cases that I've dealt with, the alienators in that case were mothers. And I suppose what I did, so what we had is we had 2 children. One was like, I think she's about 13 or 14, something like that. And the younger one was No, so I think the older one was 12. This is relevant, and the younger one was kind of 7 or 8. And the older one, who was 12, was very busy telling the younger one that their dad was pretty awful, and that the younger one shouldn't be having contact, because the younger one was actually really enjoying having contact with her dad. And in addition to that, the mother also was doing that classic thing of saying, I never speak about him to the children. They're entitled to have their own opinion about their dad. I don't want to interfere with that. You know, that kind of classic alienators, like fig leaf, really. And what this judge was a judge who wasn't initially very concerned about this case. It was a case in which we turned a final hearing into a hearing that wasn't final, because once he'd heard the evidence, he became very concerned about the mother's approach, and also about, it wasn't just the mother's, it was also the older child's approach, and the way in which both the mother and the older child created an environment that meant that even if this younger child was enjoying contact right now with her daddy, that was not going to remain the case. I mean, I just couldn't see how realistically you could expect this child to continue seeing her father when everybody that was important in her life, her day-to-day life, was vehemently rejecting him. So I think the way that you deal with that is obviously it's an evidential base, it's a support for why there needs to be a transfer of residence, because basically what you're dealing, I mean, a mother can be expected, an adult can be expected to kind of self-censor, but a child of 12, I don't think realistically can. And what the court did in that case was, we still haven't concluded it, but in respect to the older child, an interim, the court refused to conclude that case, even though the guardian had suggested that the court did. And so it still made it clear that it was considering a transfer of residence in respect to the older hostile child. That's why the age was important. And in respect to the younger one, it approved the status quo, which was a kind of quasi-shared care arrangement. But because it had not concluded the older child's arrangements, that was kind of a Damocles sword, it seemed to me, on the mother. And actually, it's one of the few cases where I have agreed on the alienated parent's behalf that they engage in therapy, because I know now that this mother is genuinely terrified that she's going to lose both children. So, Hattie, I know that's not about every case, but I suppose the points that I would say that you, to deal with your question, for a start, it does happen, although it's quite rare. But secondly, I think it's a really, really important part of the dynamic which the family need to consider. In my opinion, guardians don't often deal with this very well, and not realistically. But then I don't think very many professionals have an enormous amount of experience of this. But yes, it's all kind of grist to the mill. It makes it makes it a very interesting case. So I'm pleased that you found that helpful. I felt like I was just going off on a bit of a tangent there, but I'm glad it was.
I would thoroughly endorse what Anarkali has said, and in my experience, debunking the myth of the alienated parent being that ogre is so important. And the way you do that is make sure that you've got a court who understands the risks of this at final hearing, and work back so that your interim contact measures are extensive, whether that's lots of time or lots of frequency. And therefore the child who is trying to be positive but is possibly being alienated is seeing the reality of the other parent, and therefore has their own experience to compare and contrast against the alienating behaviours within their household. There's another question, which is there any reason judges you see are not keen for shared residence? I think it's increasingly becoming common to have shared lives with orders. And even though sometimes it can still look like the old-fashioned weekend contact and maybe a tea time visit, the REA power struggle principles are really useful in these cases, in my view. And the ability to say that it doesn't matter about quantum, it's about the nature, it's sometimes very important what label is being put on it, not dismissing it as a a weekend parent is a really important point in these cases where the resident parent is often quite dismissive of the other parent and can be overtly dismissive. Often that's by challenging parenting styles, but we know, and all the case law tells us, you can have different parenting styles and you don't have to get on to have shared lives with orders. So rely on those, in my view.
Yeah, I totally agree. Now, another question has been sent to me privately because the author actually was a bit worried about it being quite a long question, but it's a really good question. So I'm going to read it out and she's happy for me to do that. And she says, I've got a matter dealing with this issue in court. This is to do, I think, with the age of children. And the first hearing took place last week. 16.4 has been appointed. There's a significant history between the parents, but the children are 16 and 14. The court's made it clear that orders will be made only in exceptional circumstances in relation to the 16-year-old, and the children continuously send abusive correspondence to the mother that echoes the father's views. So I think this is a really good question because there are 2 points here. It's about the combined dynamic of the siblings. And actually, I forgot to mention a case when I was dealing with the other question about siblings, which I'll raise in a second, but also to do with the ages of children about whom you're litigating. So I'm going to just talk about those quickly. First of all, I think when you've got children who were 16 and 14 for me is realistically the absolute upper limit of children about whom the court can have any sense that litigation might be effective. I mean, you might have a 15-year-old who's on the fence. It depends. If there is really intransigence, if there's real intransigence on a 14-year-old, I think you're going to struggle to get that one back. If you've got a 15-year-old that's kind of sitting on the fence, then actually you can do something with that. A 16-year-old who is writing abusive letters to their mother because their father has told them to, or essentially has created an environment where they're expected to do that to win approval, is a child about whom very little can be done, sadly. That's my professional opinion. I think I've never come across a case where anything we've ever done has been effective for a child that age. But I think what interested me about that particular question is this dynamic of a 14-year-old and a 16-year-old together, and to what extent can any work with a 14-year-old be effective when you have a 16-year-old in the house that's going to basically run against any of that, even if the resident parent, in this case the father, is paying lip service to what the court wants him to do. So last year, right at the end, it was the case of Re P. Do you remember this one, Sophie? It was in front of Wild Blood. We'll write all these cases down for you later if I think there is a desire for that. But basically, Wild Blood kind of went complete. He's a judge who does quite like to lament, it seems to me. But he really lamented the fact that there'd been so much delay in this case, and a whole group of siblings really had begun to hate their father about the time when it started when the father left, and because there was no proper intervention by the court, you know, this kind of status quo of them never seeing their dad and hating their dad was just allowed to take root, and really produced an extreme situation where the judge felt that it was in their interests at some stage to send them all back to their dad, notwithstanding their own feelings, which were obviously alienated, but nevertheless held quite strongly. And it was an incredibly unsuccessful move on that judge's part. And I think for me, when I read that case, because it came after the cases that I was involved in, Re-L and Re-H, which involved, you know, these only children, these boys, kind of, they're not exactly the same age. One was 8, one was 12, but that kind of age, where you actually can do quite a lot with a child that age. But when I read Re-P, I remember thinking, well, I would have been very doubtful about this ever working anyway, because a sibling dynamic, one child on its own, or, you know, I think you can do quite a lot with, but when you, or even one child and another child who's not entrenched, you can do a lot with. But when you've got kind of 2 or more, or a whole pack of kids who are busy actively loathing one of their parents, I don't really think you can do much with that. And it's not surprising that in Re-P, the judge's attempt to restore both parents to their life was completely unsuccessful. So I think really the problem, I would say, to that excellent question, is that you're on a sticky wicket. And it's really difficult to know how you're going to litigate that with their ages, because it really depends, it seems to me, on the extent to which the 14-year-old is going to be influenced or is vulnerable to influence from the 16-year-old. I mean, is she able to individuate herself from her resident family, or is she somebody that is her behaviour simply a manifestation of the overwhelming dynamic of that case? And that's something that's very kind of fact specific, so it's kind of hard for me to advise beyond that, but it's not looking great, sorry.
Well, it's been a huge pleasure to conduct this webinar this morning, and unless there are any other questions, I think we should draw it to a close.